Alright, continuing subpart C and D. Alright, part 24, volume 1, title 40 CFR Code Regulations. 2415, hearing oral presentation written submission by parties. Presiding officers should conduct the hearing in a fair and impartial manner to take action to avoid unnecessary delay with the disposition. Proceed with the maintaining oral of the presiding officer shall permit the oral statement on behalf of the respondent of the EPA. Presiding officer may address questions of the respondent of the EPA to representative during the hearing. Each party shall ensure representatives is or are present at the hearing who is or are capable of responding to the questions, articulating with the position on the law and the facts of the issue. Part of the question by presiding officers, no direct examination, cross-examination shall be allowed. Upon commencement of the representative of the EPA shall introduce the order, reporting issue of the order with a summary of the basis of the order of the respondent may respond with administrative record and offer any of the fact statement of the explanation of the documents which bear any issue which for the hearing has been requested in such presentation. Respondent may include the new documents only to the extent of the respondent can demonstrate that there is no fault of its own, such that the document could not have been submitted with the vote being for hearing in accordance with the railroad agreements of the 2414C and E. Agencies may then present matters solely with a rebuttal to matters that were previously presented by the representative. The presiding officer may allow the respondent to respond to any such rebuttal submitted with the presiding officer. May exclude representative of the relevant matter with the presiding officer may, upon request, grant petition relief of the respondent submission made with the respondent pursuant to paragraph 2414E. 2416 transcript or recording of the hearing. The hearing shall be either the transcript of the stenographer graphically or tape recorded. Upon written request, such of the transcript and tape recording shall be made available to inspection or copying. Transcript required recording of the hearing and all written submitted to the file with the clerk by parties subsequent initial assurance the order included post-hearing submission will become part of the administrative record preceding the consideration of the presiding officer regional administrator. Alright, 2417, presiding officer recommendation. The presiding officer will also soon practical after the conclusion of the hearing evaluate the entire administrative record and or on the basis of the administrative record prepare and that unfiled recommended decision of the regional administrator. Recommended decision must address all of the material issue of the fact of the law properly raised by respondent. The must be recommended the order must be modified written issue without modification of the recommended decision. Must be provided explanation, citation, material contained within the record, any of the decision modified with the term of the order, the issue of the order without the change of the withdrawal of the order, and the recommended decision shall be based on the administrative record. The presiding officer finds any of the contested relief provision of the order is not supported by a preponderance of the evidence in the record. The presiding officer shall recommend that the order modified and issued the terms supported by the record withdrawn at any time the 21 days service of the recommended decision of the parties, and the parties may file comment and recommend decisions with the clerk. The clerk shall promptly transmit any of such comments received with the regional administrator for the consideration and reaching final decision. Alright, Subpart D, post-hearing hearing procedures, final decision. As soon as practical after the receipt of the recommended practice, the decision of the regional administrator will either sign with the modified recommended decision, issue final decision with the regional administrator modified the recommended decision, has ensured final decision indicated the legal and factual basis for the decision modified with the regional administrator. The decision shall be based on the administrative record. 2419, the final order. The regional administrator may not adopt the portion of the initial order finding with the modification of the order of the necessary signatory official of the initial administrative order shall modify the order in accordance with the terms of the final decision file served with a copy of the final administrative order. If the regional administrator finds the initial order operates as original issued, the final decision shall declare the initial administrative order the final order. Effective upon the service of the final decision for regional administrator declare that the initial order must be withdrawn with the signatorial official. Initial administrative order will file and serve the withdrawal of the initial administrative order. Then this may be done without prejudice. 2420, final agency action. Final decision of the final administrative order or final agency actions are effective upon filing. Serve these actions are not appealable to the administrator. And that was part 24. Your rules governing governance of administrative hearings and interim status corrective actions.